appearing for Eacc, together with Mr. Ben Murray. Ben Murray. Mary Nganga. Lydia Njiru. Elijah Njiru. And Ms. Lekiyeyo Joyce. Lekiyeyo Joyce. Those are the councils for Eacc.
Having gone through the two files, I have noted the following: that in this particular file, there are four applications. The first application is dated 12th March 2025 and was filed ex parte. This is the application in which the impugned search warrants were issued by my brother, Honorable Eacc.
Filing a notice of appointment is a procedure unknown in law. It is our submission, Your Honor, first and foremost, that the application by Mr. Achoki, who is a proposed interested party, should be canvassed, and the court rules on whether they should be admitted as a party or not, and that is when they can have locus to address this court on the substantive issues that are before this court. But for a party who is yet to be admitted as an interested party, the person is just a proposed party, to come to court and say, Eacc, which obtained the warrants, have no locus, yet they themselves have no locus in the first place.
Your Honor, allowed to interject. The question before this court is only one: whether Eacc has locus to address the court. Any other issue is not before this court.
I think it is, I'm right to argue my case, and the court will rule whether I have argued my case. The party saying I have no locus cannot dictate how I should proceed in making my arguments.
Yes, but proceed. The court basically gives you the right to reply to the submissions which were made yesterday. So I suppose maybe you know the submissions that were made.
And I think I'm right to say, even those who are saying I have no locus, they themselves have no locus. The issue is about locus. If somebody says I have no locus, we should also ask if the proposed interested party has locus. Proceed. And that is my submission.
Calm down and proceed.
And Your Honor, I should say Eacc as statutory body established under Article 79 of the Constitution and pursuant to the Eacc Act 2011, Article 79 of the Constitution of Kenya, which obligates the National Assembly to establish Ethics and Anti-Corruption Commission. And pursuant to that article, Ethics and Anti-Corruption Commission Act was enacted. Which grants the Ethics and Anti-Corruption Commission the mandate to investigate and make recommendations to the Director of Public Prosecution on criminal matters and matters of breach of ethics. Your Honor, Kenya is a signatory to the United Nations Convention Against Corruption, which they ratified in 2003 December. and which obligates the Republic of Kenya to domesticate the convention. And it is pursuant to the domestication of that convention that the Ethics and Corruption Commission was established as the lead agency in the fight against corruption in Kenya. And in the course of its investigation, EACC is granted powers exercised by the police under Section 23 of the Anti-Corruption and Economic Crimes Act. And in the discharge of its functions, it is to discharge its functions independently, pursuant to the provisions of the Ethics and Anti-Corruption Act. Being an investigative agency, it is empowered to apply the provisions of the Criminal Procedure Code, which powers include to apply for warrants. It is in the execution of those powers that it moved to court following credible information that it had and obtained warrants. The power to prosecute, Your Honor, is bestowed on the Director of Public Prosecution. The Director of Public Prosecution does not investigate and does not apply for warrants. The law allows an investigator to depone to court why they want a warrant. And it is the investigator, which in this case, the EACC as the investigating agency, that is granted those powers. And having obtained the warrants to search and executed those warrants, the applicants cannot be heard to say the investigating agency does not have lockers when they themselves are applying to undo those orders. We submit that at this stage, in the course of investigation, the Director of Public Prosecution has no role. It is the investigative agency. And as such, we rightly move the court to apply for such warrants. And any objection to those warrants, we are right to respond to any application that is made before this court. Your Honor, at this point, I wish to request that you allow my colleague, Mr. Murray, just to mention one or two things. Along the same line.
So your address on the authorities.
start by pointing out that, you know, the application made by my colleagues was not an application, a standalone application. It was an application made in the context of pending proceedings, in which they made specific allegations, not against DPP. It's a mockery of justice. It is unheard of in any jurisdiction, not even in failed states, but certainly not in our jurisdiction. The right to be heard is a fundamental principle of justice.
Whether Mr. Murray here can stand. In fact, there was a senior counsel yesterday who put it in quarter in a very funny way that you should not even open your mouth. So basically, the court is trying to resolve the issues around that. And thereafter, I think we'll be able to now check proper directions on each application. In my ruling today, of course, I've pointed out what I've seen in the file. So we are not in any way, and we've not done that, purported to give any directions on any of the applications before court. There's a lot of court, of course, the court will say about each application, and some of them are cited issue. But before we can for now, those directions. So it was allowed this year, yesterday, so that will, in my so I need to retire and consider the issues raised.
For my colleague to say that he will produce the proceedings and the order and make it part of the ruling, I think that is jumping the gun. I would rather, just a minute, I would rather the court delivers the ruling based on what we have submitted, and thereafter we will take direction. Because even us, we intend to raise issue about abuse of the court process. That we are in the High Court on the same things, validity of the warrants, and we are before you again on the same things. But for now, let's just confine ourselves to the ruling based on our submissions. Then thereafter, we will take directions on how we proceed.
Yes. So that I do not find myself issuing orders that contradict the High Court orders, I direct that the orders by the High Court be extracted and provided provide to this court before the ruling date that I'll issue shortly.
The court can access those orders directly without these parties. People's bread is at risk. Kindly let the court get the orders directly from the High Court.
I would
actually, the constitution of courts orders extracted directly.
Yeah.
If you wish to supply to the court the authorities that we
it's okay, yeah.